What is a copyright? A copyright is an intellectual property right granted by a government to the author of an original literary, dramatic, musical, artistic, or other eligible creative work. It gives the creator the exclusive right to control how the work is published, reproduced, performed, or displayed. It also allows the creator to control whether or not derivative works, such as a movie adaptation of a novel, may be produced. In the U.S., the founders set the legal foundation for copyright in the Constitution in Article 1, Section 8, Clause 8. This clause gives Congress the authority to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Congress and the courts have interpreted the terms authors and writings very broadly. This allows them to protect many different types of creators and content. Title 17 of the U.S. Code allows copyrights to be granted to the authors of original works of authorship, including books, plays, choreography, graphic or audiovisual works, sound recordings, and architectural works. Typically, a copyright lasts for the life of the author plus 70 years. How does an author obtain a copyright? In America, the U.S. Copyright Office runs the copyright system. Interestingly, obtaining a copyright does not require registration. It is granted to an author as soon as his or her work is written down, saved electronically, recorded as video or audio, or otherwise expressed in a tangible way that allows it to be seen or copied. Copyright holders only need to register their copyright if they want to file a copyright infringement suit in federal court. How do copyrights and patents differ from one another? While patents and copyrights seemingly try to accomplish similar goals, they are distinct from one another in important ways. Determining merit can be far more subjective for a creative work than for patent-eligible inventions. For this reason, the U.S. does not have any examination system to determine whether a creative work merits copyright protection. This is not the case with patents. Patent and copyright systems are similar, however, in that they both recognize the importance of protecting the property rights of creators. Protecting those rights gives inventors and authors the incentive to create. By giving creators the incentive to create and share their ideas, the copyright and patent systems are designed to harness individual creativity for the public good. However, patents and copyrights use different approaches for promoting the public good. While ruling on Whitney v. Emmett in 1831, Supreme Court Justice Henry Baldwin explained that the explicit intention of patent law was to benefit the inventor in the belief that maximizing individual welfare leads to maximum social welfare. Inventors, after all, created tools that would help the U.S. develop an independent economy. Whatever incentives were needed to motivate inventors to create useful new tools, the benefit outweighed the cost. With copyright, however, the rights of authors were thought to be at odds with those of the public. Zarina Khan, author of The Democratization of Invention, Patents and Copyright in American Economic Development, explains, democratic values emphasized equal and widespread access to learning and the importance of information flows for maintaining political freedom, whereas strong copyrights impinged on the fullest attainment of these objectives. As an example, while a copyright holder has the right to prevent unauthorized use of their work, that right comes into conflict with the First Amendment right to speech, hence the doctrine of fair use. Lawmakers felt that creating strong patent rights but weaker copyrights best reflected the different incentives that motivated inventors and authors. Many thought that inventors were driven primarily by economic gain, while authors were motivated by fame just as much as economic gain. Supreme Court Justice John McLean emphasized that this distinction exists in the structure of U.S. intellectual property law itself. In Wheaton v. Peters, 1834, the first high court ruling on copyright, he wrote, "It has been argued at the bar that the promotion of the progress of science and the useful arts is here united in the same clause in the Constitution. The rights of authors and inventors were considered as standing on the same footing. But this, I think, is a non sequitur. For when Congress came to execute this power by legislation, the subjects are kept distinct and very different provisions are made respecting them." To understand why the founders gave greater weight to the public domain in copyright law than they did in patent law, it's important to examine the origin and development of early copyright systems and their political and economic impact on society.